Now the floor is to Sir Francis Jacobs, KCMG QC, a longtime supporter of this conference, who will give his keynote address. Thank you.
Thank you very much. It is certainly a great pleasure and a great privilege for me to give the keynote address in opening this conference. And I'm delighted that the British Institute, led in this project by Julinda, has been able to organize this 21st annual conference on international trade law. I recall that the idea for an annual WTO conference goes back to a review by the British Institute of its program, a review which took place at what must be the end of the last millennium. I had the idea then that we should take advantage of the annual visit from the United States to Europe of Professor John Jackson, the very personification of world trade law, founder of the Journal of International Economic Law, and a very good friend. The idea was to arrange with him, and with his enthusiastic support and stimulating presence, a major annual conference in London. The first was held in London in the year 2000, and it has taken place every year, continuing after John died in 2015. I have to say that this year's conference takes place against a scenario which I think both he and we would not have found credible even a very few years ago. All the more reason to discuss and debate it as a matter of urgency. For this conference, we have a remarkable program, as Julinda has outlined. However, in my brief presentation, I want to return to first principles and to focus on recent developments concerning the rule of law. And I will focus on the United Kingdom and the European Union, and more briefly on the United States. The European Union, despite its great problems, remains one of the more remarkable achievements of states, of statesmen and women, and of international law. Despite internal difficulties, recently with some of its own member states, notably Poland and Hungary, in conflict with the rule of law, it has remained a model for other regions to emulate. In the context of international trade, at an early period, it could be charged with protectionism. But there has been improvement here, partly, I would suggest, through the good influence of the United Kingdom. The role of the Court of Justice has been key. Overall, member states have successfully subjected themselves to European Union law. Notably, they have strengthened Commission action against themselves, introducing financial penalties against the member states, which have made the Commission's enforcement powers extraordinarily effective. The United Kingdom has made its own criticisms of the Court of Justice, but I would say that for almost the whole of its period of membership, approaching 50 years, the United Kingdom has been a valued partner. Inevitably, some criticisms could be made of the Court of Justice in sensitive and significant areas. One example, perhaps, being its approach to investor-state dispute settlement arbitration in the Achmea case. It is one thing to seek to ensure that the Court of Justice has a broad jurisdiction to secure as far as possible the rule of law within the European Union. It is another thing to seek to disentitle other systems of dispute settlement, especially where, as in that case, the European Union, through the European Commission, had itself encouraged the establishment of those systems. Encouragingly, there are signs of a partial retreat by the court in its opinion on the EU agreement with Canada. Another example outside the field of trade law, but again apparently concerned to protect some form of monopoly for interpretation by the Court of Justice, is the surprisingly negative opinion of the Court on the issue of accession by the European Union to the European Convention on Human Rights, the foundational human rights instrument of Europe, binding far beyond the European Union on all 48 European states except Belarus, and about to celebrate in a fortnight its 70th birthday. There must be a hope that the question of EU accession to the Convention, a foundational issue of EU law, can and will be reconsidered by the Court in the not too remote future. But while some criticisms of the Court of Justice could even be founded on a lack of concern for the rule of law, such criticisms would currently be difficult for the United Kingdom to make. The Brexit saga has just now produced an alarming development in the United Kingdom, the Internal Market Bill currently before Parliament. Whatever views you take on the merits or demerits of Brexit, the current British government's approach to international law, as adopted in this bill, has raised a torrent of criticism, and I make no apology for focusing on this very topical issue. Voices from across the political and legal spectra have denounced the deliberate decision of the government to break international law in enacting the Internal Market Bill now going through Parliament, which openly and admittedly violates the treaty concluded between the United Kingdom and the European Union less than a year earlier. The bill would allow the government to override provisions of the Northern Ireland Protocol signed by the current Prime Minister last year, provisions which allow for checks on goods crossing between Northern Ireland and Britain. The threats to the rule of law contained in the bill are found not only in that flagrant breach of international law, but also in provisions of the bill that purport to oust the jurisdiction of the UK courts and to exclude the application of all law to regulations that may be adopted by ministers. Looking at responses in the UK itself to that bill, the two most recent presidents of the UK Supreme Court, David Neuberger and Brenda Hale, and two former Lord Chief Justices, Lord Thomas and Lord Judge, have challenged it, David Neuberger describing it as shameful. There have been several resignations from high office, including the Treasury Solicitor, Jonathan Jones, and the Advocate General for Scotland, Lord Keane. The professional bodies have also reacted strongly. The Law Society, representing solicitors, and the Bar Council, representing the bar, have each produced briefing papers, and the Law Society has opened a platform whereby solicitors can email their members of Parliament to protest. Perhaps even more remarkable, there have been strong protests from no fewer than 5 former Prime Ministers of the United Kingdom. And in a step which seems without precedent, the church leaders from across the United Kingdom have united in protest by letter in Tuesday's Financial Times, no less. Last but perhaps not least, Amal Clooney, the very well-known human rights lawyer, has resigned her post as advisor to the United Kingdom government in a strongly worded protest. This wave of outrage is, I think, unprecedented, and it is particularly impressive because there is a concern for international, not domestic law. Here is perhaps a recognition that the rule of law is all the more important, even more vital in that field. So one might even take some reassurance from this multiple and far-reaching reaction. It suggests that the spirit of the rule of law is undimmed. On Monday this week, the bill had its second reading in the House of Lords. There, a motion was tabled by the former Lord Chief Justice, Lord Judge, now the convener of the non-party members of the House of Lords, stating that, I quote, "This House regrets that Part 5 of the bill contains provisions which, if enacted, would undermine the rule of law and damage the reputation of the United Kingdom." On Tuesday, that motion was passed by a majority of 226 members of the House of Lords. Recently, the bill has been the subject of a valuable report by the Bingham Centre for the Rule of Law, a centre which it is particularly appropriate to mention today. The centre was founded in 2010 by the British Institute of International and Comparative Law to take forward the vision of Lord Bingham of Cornhill, the preeminent UK judge of his generation, who crowned his judicial career by leaving us arguably the best account of what the rule of law means in practice and why it is so important in any civilized society. That is in his book, The Rule of Law. As the centre itself tells us, and I quote, "It was an inspiring vision then, with the rule of law coming under increasing strain. Today, it has become an urgent vision, as the institutions on which it depends to give it life are becoming more systematically undermined, requiring renewed effort to reach wider audiences about the meaning and fundamental importance of the rule of law." As I have mentioned, the Bingham Centre has just published a serious condemnation of the Internal Market Bill, but it is also working on other fundamental rule of law issues, including current UK government moves to limit judicial review of government action. To return briefly to other international trade law issues of the rule of law, the United States has, of course, maintained and developed what has been described as a wrecking approach to multilateral trade regulation, including, of course, crippling the WTO Appellate Tribunal by the simple expedient of refusing to nominate members. But this increasingly seems part of a wider agenda, embracing contempt for international law generally. It is exemplified in the context of international trade by the preference for the deal, especially a more or less informal bilateral agreement, in preference to a multilateral rules-based system. It might, I suppose, be recognized that in business, a deal may have advantages, and there may also be other factors, perhaps a side deal, perhaps some tax benefits, who knows, which may make it a more attractive prospect to the businessman. But for the regulation of international trade, that is no substitute for an agreement publicly reached based on recognized rules, independently interpreted, enforceable before courts or tribunals. It is no substitute for agreements and rulings on which traders and others can rely, which they can enforce if necessary, in accordance with established rules of international law. More generally and across the board, the current United States approach seems to reflect more than ever a narrow nationalism, and that nationalism can rapidly become infectious and spread to other nations. Indeed, other areas where international cooperation could be particularly valuable is in dealing with a pandemic, or indeed in saving the environment. And now, in the context of the United States presidential election, due to reach its final stage in just a fortnight, there is even some serious discussion among observers of risks to the very existence of a democratic system in the United States. Threats which would have been totally unthinkable just a few years ago. As so often, language is important. By way of example, governments should perhaps stop talking of their own systems as world-beating. Both the United States and the United Kingdom have adopted this approach in speaking of their systems for dealing with the current pandemic. But especially if those same authorities seem simultaneously to be attacking in other domains what truly might be one of the better systems in place. In the United States, it's very a democratic foundation. In the United Kingdom, the constitutional conventions which preserve the separation of powers and the role of Parliament in a democracy, the role of the courts, the independence of the judiciary, in a phrase, a broad and proper understanding of the rule of law. The rule of law in itself is not sufficient. We are all too familiar with other alarming underlying features which could be as fatal metaphorically as a pandemic. Two in particular which seem to have the capacity to spread alarmingly. One, the growth of populism as against democratic systems of government under the rule of law. And two, social media and fake news. And I would add, not the fake use of the term fake news as exploited by politicians to undermine any reports which they see as adverse, but what we should perhaps call genuinely fake news. But while the rule of law is therefore not sufficient, it is certainly essential, and it is for lawyers absolutely fundamental. What then can we do? Lawyers, both individually and as a profession, can react. The action taken in the United Kingdom by the Law Society and the Bar Council provides one example. No doubt there are many examples with professional bodies elsewhere. We should not hesitate to respond and to react. There are many other national bodies with different functions but similar concerns. In the United Kingdom, for example, the Justice, the Bingham Centre, and the British Institute of Human Rights. In Europe, the European Law Institute, which is examining fundamental constitutional principles. Wider still, the International Bar Association, the International Law Association, the International Association for Judicial Independence and World Peace, among others. So I end with every good wish for the conference and in the hope that it will strengthen the resolve of all of us to uphold the rule of law. Thank you very much.
Thank you very much, Sir Francis, for this insightful introduction to the different topics and themes that will be discussed in the different panels, and not least for mentioning the important role of the rule of law and its cross-cutting importance as a governance principle. not only at the national level, but also internationally, and of its importance also for international trade law and the WTO, as highlighted by the finance and health ministers in their communique, September communique at the G20 meeting, mentioning the rule of law as one of the principles of the WTO and of international trade law more broadly. So thank you very much. We will close this session now, and the first panel will start at 1 p.m. UK time. Thank you very much. We will meet later. Thank you.